The German military expeditors, in a bid to conquer Seoul, launched several violent expeditions, several violent attacks against the Seoul people.
We are who we are because of Ngonso. We are what we are because of Ngonso. So taking away Ngonso's statue, which symbolizes that woman that founded the Nso Fondom, is like taking away the God that protects the land. And that is why the absence of Ngonso from Nso land is like a calamity on the Nso people.
We can deduce, for example, that the Ngonso, the beautiful sculpture of the founder and guiding spirit of the Nso people of Cameroon, a former German colony, could not possibly have been obtained under benign circumstances. Because why would you willingly give up your guiding spirit?
So we could not wait any longer. After close to about 30 years of attempts to get back Ngonso, finally in 2021, I had to travel to Germany to protest against the showing of the exhibition of Ngonso at the Humboldt Forum, and that followed with a couple of workshops with the Nso community and the Prussian Cultural Heritage Foundation to deepen their understanding. This royal visit, if you may, also involved visiting the Linden Museum that is keeping a lot of our royal collections, and we are currently requesting for 28 royal heritage that works complementary with the Ngonso. The biggest challenges that we are faced during this campaign is the lack of legislation that supports restitution. There is no legislation out there in Germany that states that institutions must return, must restitute collections in colonial context. Otherwise, this kind of punishment could apply. And so we are still depending on people acting out of goodwill. We're depending on people acting out of, their moral and ethical values. We are still depending on people who are rather doing restitution as a means to whitewash colonial guilt. We are rather dealing with people who are rather doing restitution as a means, to join the moving train, because right now the train is moving, restitutions are happening all over the world, the conversation is deepening, but people are not doing it out of the recognition that this is also a part of justice for a people who were tortured and killed, who lost their dignity in the colonial experience. And so it is important for legislation to be enacted to support restitution processes.
Good evening, everyone. That's me. But before me, that was Sylvie Djibouti, who is a Cameroonian activist, storyteller, film producer, and human rights activist. She is also a grantee of the Open Society's initiative for the global restitution of African cultural heritage, an initiative co-led by myself, Veronica Shatland, for those of you who haven't met me yet, and I'm looking forward to meeting many of you, and my colleague Ibrahim Young, who is not here. Before we start, I just want to give a thank you to my colleague Gretchen Rohr, who is here, who helped put this together, the ECCHR, and Human Rights Watch for holding this event. So thank you all for joining. And when I met with Gretchen a few days ago, actually, she asked me if I could come to Berlin and talk about this event with restitution reparations. And to be quite frank, I'm a little bit tired of repeatedly having to talk about why restitution is important. Simply because, if it's not obvious by now, restitution is a human right. It is a basic cultural need. Everyone has the right to access his or her history, regardless of background, race, or culture. It's a human right. And at Open Society Foundations, we are a global philanthropy based on human rights. Sylvie is a powerhouse. She literally was a film producer in Cameroon, and one day she sat with her grandmother and she asked her grandmother, "What would you like to see in life?" And our grandmother simply responded, "I would like to see the return of Ngonso." Since then, Sylvie has made it her life mission to come to Humboldt Forum, to come to Berlin, to sit with little to no resources at round tables being told over and over again, no. And she still continues to persevere. So could you imagine if Sylvie had the right resources, the right litigation, what that could do for her and her community, and so many communities alike that have suffered at the hands of violent looting during colonialism. What got us here, what got Open Society here, once again, is we believe that the right to culture and heritage is a human right. Whether intangible or tangible, everyone has it. But what really matters is the access. How can we know what our history looks like when it's sitting thousands of miles away in various museums that we can't get visas to, we can't even watch on television sometimes, and our history books are filled with the notes and storytelling of others. So many of the organizations that we support also believe that it is a human right. An example of this, besides Sylvie, is Open Restitution Africa, led by two young women, one based in Kenya and one based in South Africa, who have created a network of women, of Black African women who sit together and think of different ways that they can tell their stories without actually having artifacts, pictures, or objects to tell these stories. Together, they have created a global network that connects social leaders, activists, community leaders, artists, and people who work in cultural heritage. And with that said, I think that this event, thank you, Gretchen, for holding this. I'm no longer tired of answering that question. I will continue to answer the question of why restitution and reparations is important until we get back some of these objects, well, all of these objects, and a true restitution, meaning without conditionality. Gretchen, I'm going to pass it over to you. I want to introduce you all to my amazing colleague, Gretchen. She's a strategic litigation officer who contributes to the Justice Initiative's pursuit of reparations for colonial era and contemporary human rights. In 2017, she launched the first grant-making portfolio dedicated to repertory and transformative justice within Open Society Foundations US. Prior to her arrival at OSF, Gretchen was appointed the magistrate judge serving the DC Superior Court. Her early career as a class action litigator with the Southern Center for Human Rights redressed the mistreatment of children and adults behind bars or subject to death penalty. Most notably, she was part of Holland and Knight's teams securing reparations for survivors of the Rosewood Massacre, as well as securing the release of Angola 3, who spent over 21 years in solitary confinement. Gretchen founded and directed the jail and federal prison advocacy projects for people with disabilities and taught as both clinical supervisor and adjunct professor at Georgetown Law Center in Washington, D.C. Everyone, Gretchen Rohr.
Thank you so much, Veronica. If any of you wonder why in the world did it take just 2 days before this event to confirm with Veronica, because the woman does not stop moving. I mean, who else can you say, hey, can you be in Berlin in a few days? And it's like, sure, because I have a lot of work to do there. And it was wonderful to be able to meet some of the folks that have been working with her. Welcome, welcome everyone. Thank you so much for joining us. I wanted to make a few announcements about this space. There has been some rain coming down on us from above. So please be aware if there's, I know I really appreciate the facilities here have taken every step to make your time comfortable here. But if there are any concerns, if you do see anything, say something. We want to ensure that there will be no electrical catalysts other than the conversation catalyzing some sparks in our work today. Also, if you're not aware, there are restrooms through the hallway here and immediately up the steps. If you do need accommodations as to navigating those steps, you can speak to some of the facilities or event program support staff to my left. So let me ask you, how many of you have all the support necessary for you to litigate human rights, the human right to reparations? Anyone here got it all handled? Is your strategy embedded as much as you want within or aligned with the goals of your movement partners, of cultural producers, political organizers, community leaders? How many of you feel like you got that handled? You got it down? All right, well, I don't. It's an honor to welcome you on behalf of the Justice Initiative. And like many of you, I'm here to engage a network. I really want to engage and resource you all as a network of like-minded advocates committed to reparations as a human right, not something that is to be secured, achieved. It is our right, and it's one that needs to be recognized and has been and pushed for by those that you saw in the film today and by many of you in the audience. We look forward to engaging your expertise and supporting and resourcing the steps forward. It's very important, therefore, for all of you in this room to know who's in the room. Make the most of the time that we have together. This is a series of convenings, one of many, that we hope will connect you to the resources of practitioners who may be available alongside you as attorneys and other subject matter experts as you're pursuing matters potentially in domestic, regional, or international tribunals. So in a moment, I would like to invite our local hosts here from Germany to please stand. We have staff here from the European Center for Constitutional Rights, if you could please stand. All the staff from ECCHR. We got some other folks. Come on, y'all. Don't be shy. Thank you. And will those from Human Rights Watch, our other co-sponsor in this program, please stand? Thank you. And finally, I'd love to hear or love to see those of us who've traveled here for an event that really is going to be focusing and highlighting on the work relating to Germany's atrocious acts and colonization, but many of us do not live here. So how about those who've traveled from outside Germany to come to this event tonight? If you could please stand. I know there are a lot of you. So hopefully we've encouraged this evening's event. It was the intent to really structure it in a way that will enhance, give you some ability to contribute to this global debate on reparations. As was stated and noted by my colleague, Veronica, cultural leaders and many others have shifted our understanding of reparations. What we see here happening, we never would have imagined 5 years ago. In spaces we hear about reparations, restitution, repatriation, The momentum has grown in the public sphere and the public dialogue, even as many of you have been behind the scenes, plugging along for this, for your communities, and for your family members for decades upon decades. So it's about time we catch up, right? There's a phrase often stated that law follows culture. And when we look at how much our culture has changed with this new evolution of the racial justice movement, with a new evolution of recognizing and challenging what we know about human rights, where's the law going to be in 5 years? What is the future of human rights law, recognizing that our present discussions of reparations don't look anything like they did when most of human rights law was considered to be established? So some of what we're going to be talking about, and many of our partners here, in addition to our highlighted speaker, we're going to have a panel before you who will share with you some of the ways in which they're navigating the critical questions that may arise in all of your work. How do we shift from principles to practice? They're going to talk about those steps. They're also going to talk about a bit of how lawyers need to be able to speak with community members about this right. What's the language to use? Many say, there's the R word. Don't say the R word. Do they mean reparations? Do they mean restitutions? Do they mean a revolution? So it's quite an honor that I have to introduce our first speaker, who will highlight for us an example of what many of you are aware of here in Germany, I hope, and not enough of us are aware of the complicated work that has been done in the representation of the clients that our speaker, Patrick Kaute, has been working with and has arisen from. Patrick Kaute is going to offer us a snapshot of the colonial crimes that have been committed by Germany in his region, and highlight some of his work on the constitutionality of this joint declaration between Namibia and Germany. Let me just say a little bit about him. We can skip to the next slide so we can see Mr. Kaute's amazing image. Thank you so much. Patrick Kaute is a prominent lawyer in Namibia with 26 years of experience as the director of Dr. Vida Kaute and Hoveka Inc. He founded a law firm, Kaute Basana and Kamahanga, in 2001, which then later merged with his current firm to form itself as WHK. And in September 2016, it was a fully established firm. His expertise is much too lengthy for me to describe here before you, but there has been quite a bit of focus and accomplishment in his work in corporate and commercial law, public law, constitutional law, competition law, and commercial litigation. And his recent cases in the High Court of Namibia include litigation in the field of constitutional law, where he sought the court to set aside Parliament's decision to adopt reports in contravention of the Constitution and its own rules, and sought an order in which the court enforced parliamentary oversight over the executive. He's currently leading a team of lawyers that is using this similar scenario with challenging the governments of Namibia and Germany with respect to the unconstitutional manner in which they handled the negotiations from the genocide committed against the Over-Herero and the Namas in 1904 through 1908. Please join me in welcoming our key speaker, Patrick Kaute. Thank you so much.
Evening. I'm much taller than Gretchen, so mind adjusting the Thank you, Gretchen, for that introduction. I also want to thank the organizers of the event for inviting me to this auspicious occasion, the Human Rights Watch, the ECCHR, and Open Justice. I also want to thank particularly Nora Hender, to whom I owe gratitude for her patience and consideration in arranging that long flight. And lastly, I want to thank you, the participants and my fellow panelists, for setting aside your time for this, to listen to this important and interesting topic on reparations. I think that's the R that Gretchen was speaking to. In preparation for this event, I read a Haitian historian who wrote, and I quote, in writing the story of Columbus arriving in what was called Haiti, one has to make a decision. Are you on a boat or on the shore? History is about positioning. When the first German traders and settlers arrived in the then German Southwest Africa, it was by no means terra nullius. They were the only uncivilized. Their subsequent annihilation of the Nama and of Herero confirmed that. Surprisingly, the German government of the day says, and they are supported by the Namibian government to an extent, that according to the laws at that time, it was all lawful to kill, rape, and take property of the Herero and Nama because they were uncivilized. Namibia is a constitutional democracy that abhors colonialism. That is why we initiated the legal intervention there. Our legal intervention for reparations for colonial crimes consists of 5 elements. Firstly is the domestic litigation before the Namibian courts. Secondly is the joint communication by the United Nations Special Rapporteurs. Thirdly is the upcoming litigation in Germany. Fourthly, we seek further interventions from the United Nations. And lastly, publications in peer-reviewed journals, such as the German Law Journal. You will have noticed that Karina Tuera has written extensively on this, on legal standards, and her article on legal standards will be published soon in the German Law Journal. It is undergoing peer review. Our immediate objective, however, is to have the Namibian court declare the joint declaration inconsistent with the Namibian constitution and therefore of no force and effect. Our midterm objective is to persuade both governments to start new negotiations in accordance with minimum legal standards and thereby achieve true reparations and not development aid. Our long-term objectives are to overcome colonialism and thereby get it overturned and inscribed into international customary law. You will have to appreciate the main political and legal events that informs the context of our legal intervention. In chronological order, they are briefly the following. After independence, in 1990, political struggles came to terms with German colonialism because because of stronger education and information, especially by the Ovaherero and Nama communities. In 2006, Paramount Chief Kwaima Rirwako brought a motion to Parliament that was accepted unanimously by Parliament for restitution, apology, and genocide. By 2011, the Namibian government still saw itself only as a mediator between the affected communities and the German government. Between 2015 up to 2021, something had changed, and the Namibian cabinet commenced with interstate negotiations, led under strict secrecy, despite the fundamental importance of the negotiations to both societies. From the onset, Herero and Nama communities criticized the negotiations for the lack of participation. In 2017, they went to the US and filed a case that was ultimately dismissed because the court lacked jurisdiction. In May 2021, both government special envoys initialed the joint declaration. There was a massive protest back home that probably both the German and the Namibian government did not expect. In September 2021, the motion to debate the joint declaration was tabled in the Namibian Parliament. In December 2021, the Speaker of the National Assembly simply noted the debate. The Namibian government thereafter announced it will go back to the negotiation table and increase the quantum. Since autumn 2022, both governments have allegedly been negotiating an addendum to the joint declaration. On 19 January 2023, this year, we filed an application to the Namibian High Court, as I have already said. As scholars of law, most of you might wonder whether our legal intervention is justiciable. Unless we prove or we have material to show that it is in breach of the principle of legality. There are 5 reasons why we think and why we contend it is justiciable. Of course, these 5 reasons we will amplify after receipt of the record. The first reason is that we say that the decision by the Speaker of Parliament to note the joint declaration is not good in law. We say so because we contend that the Speaker invented a rule to note the joint declaration in circumstances where there are other rules of Parliament that speaks to adoption of motions. We further say that even on the rule that she invented, she failed to follow its condition precedents. Secondly, we say that the noting of the joint declaration by Parliament shows Parliament's failure to discharge its constitutional obligations in terms of the provisions of the Namibian Constitution. Specifically, Article 63 thereof, sub 2 Roman 1, that says that Parliament must remain vigilant and vigorous for the purposes of ensuring that the scourges of apartheid, tribalism, and colonialism do not again manifest themselves in any form in a free and independent Namibia, and to protect and assist disadvantaged citizens of Namibia who have historically been victims of these pathologies. We say specifically Article 10 and 20 of the Joint Declaration are in breach of that. Thirdly, we say on its face, on a mere reading of the Joint Declaration, it is in breach of the Namibian Constitution, because Clause 20 ostensibly forecloses the constitutional powers of Parliament to make law. If you read that clause, it says the development aid by Germany is the final act, and no laws in Namibia will be made on the issue of reparations going forward. We say the joint declaration, having been negotiated by the late Ambassador Ngavirwe, an unelected official, not from Parliament, and him having been appointed by the executive, it can never have a force of law domestically in Namibia. Fourthly, we say the joint declaration is also on its face in breach of Paramount Chief Kwai Mariruakwa's motion that was accepted, as I said, unanimously in 2006, because contrary to that motion, the joint declaration deals with colonial crimes in a manner that disregards the participation of affected communities in respect of subject matter that directly affects them. That is specifically in respect of reparations and apology. The principle of intertemporality aside, we say is also a fundamental issue of public participation, which is essential to the lifeblood of a constitutional democracy. We say public participation was limited because the activities giving rise to the joint declaration happened exclusively within the executive, who are not elected officials of Parliament. We also say that the executive has further been shielded from accountability by Parliament, who acts as the people's representatives when direct democracy is not possible. On either score, then, and in bearing in mind that the joint declaration itself ranks as an act of Parliament, which would ordinarily be subject to public participation and parliamentary oversight, we say the conduct of the executive falls far short of that. We also say that the joint declaration is not a meaningless international statement. It has domestic application and an adverse effect on citizens' rights to the extent that it has made a policy choice which has never been debated or otherwise scrutinized. The government does not have the power to unilaterally make laws on an international plane that have a direct impact on their citizens. That is a substantive law-making power that is reserved for Parliament. Absent a parliamentary mandate, the joint declaration falls to be set aside due to its overbreadth and reach. Lastly, we say that the Prime Minister, as the leader of government business in Parliament, gave a binding undertaking on behalf of the government regarding the fact that the joint declaration will be debated in the National Assembly. That constituted a legitimate expectation, which to date the Prime Minister has never rescinded, and we say that that legitimate expectation that was created and not honored is a breach of fundamental rights, including the right to disregard Parliament. Karina will speak about participation rights and the reproduction of colonial racism in terms of a decolonial interpretation of international law and the doctrine of intertemporal law. She will also touch on our approach to the United Nations Special Rapporteurs in autumn 2022 It is now common knowledge that on 23 February 2023, 7 special rapporteurs wrote letters to the German and Namibian governments confirming our international law arguments. They agree on 3 issues. Firstly, the participation rights of Herero and Nama have been violated. Secondly, the joint declaration does not contain adequate reparative measures. And thirdly, Germany has not granted reparations. Karina might say something more on why this is a breakthrough with regard to our international law arguments and the advent of domestic litigation in Germany. Before Karina elaborates further, I'll be remiss on why I'm here if I do not summarize the position of the German government and why their position, in our respectful view, is a reproduction of colonialism. The German government say that it has no legal obligation to pay reparations because no legal norms were violated when German troops committed the mass killings, the mass rapes, mass forced labor, the expropriation of property, and exterminated 80% of the Herero people and 50% of the Nama people. It relies on the doctrine of international law, which in itself is neutral and indispensable to secure legal certainty. Firstly, the doctrine of intertemporal law says that whenever you adjudicate acts that were committed before, you have to apply the laws that were enforced back then. The German government argues that. As the Herero and Nama people were considered to be uncivilized, they therefore had no legal subjectivity in terms of international law. For that reason, they could not sign treaties on laws of war and humanitarian laws that could have granted their population legal protection. The German government contends that customary international humanitarian law did not apply because Herero and Nama people lacked legal subjectivity, and those norms only applied to conflicts between states. Secondly, that the principles of humanity that were invoked at the end of the 19th century to denounce the genocide against the Armenians as unlawful by the Europeans themselves did not apply to the Herero and Nama people because they were uncivilized. This, you find, is according to the German Scientific Services paper. This position, ladies and gentlemen, in a nutshell, is that the Herero and Nama people could lawfully be killed, raped, and dispossessed of their property with impunity by those who regarded themselves as civilized, even though, as I initially quoted, they were not on the shores, they were right on our land. The German government's position is surprising, bearing in mind that both Annalena Baerbock, the Minister of Foreign Affairs, and Katja Kiel, the Minister of State and Foreign Office, have studied law and must know that their legal position is at best preposterous in a time in which decolonial perspectives to international law grow stronger and stronger. In the fullness of time, the International Court of Justice will accept the jurisprudence that Eurocentrism and the reproduction of colonial racism are contemporary acts of racism. Judge Al Kwawanesh and Judge Robinson have done tremendous groundbreaking work on Eurocentrism in the ICJ decision on Cameroon and Nigeria and on reparations for transatlantic chattel slavery. Their work will surely pave the way for us to one day argue at the International Court of Justice. And we look forward and are eager to follow that work and in any event, we say, and we categorically say, that any attempts by Germany and the Namibian cabinet to shut us down, as they intend to do in the joint declaration in Article 20, will never succeed. Thank you.
I'm going to take a second. Thank you so much, Patrick. I will invite now our panelists to join Patrick on the stage. We have Karina Tora, if you would join me here, Chief Taku, Sarah Bonney. Thank you so much. Can we hear it one more? I don't need that. I forgot I'm Oprah'd up or whatever. Can we please have another round of applause for Patrick? It does feel very odd to clap in celebration after hearing, such disturbing history and present. That I just so appreciate you noting how this is not historical, that what we are addressing and speaking of today, there's the phrase colonial era, and recognizing that colonization has not ended in many spaces, and particularly those that continue to be occupied economically, occupied in the frame and the limitations as to what rights can be pursued, occupied in the lack of access to justice. And this is a contemporary issue because there's opportunity for us to take action. I have, to the right of me, an amazing panel of attorneys who are taking action and recognizing that there are very live claims that require quite a bit of creativity to pursue, and in many ways taking the lead before many of us, experimenting in ways that possibly we can follow suit. I recognize, and I think it is very important, particularly with having our partnership with Human Rights Watch and others here, that the work of human rights, the work of advancing human rights is not all done by lawyers. But we have a responsibility. We have a responsibility, especially because human rights law has been considered to be written, defined, and advanced within the field which many of us have committed ourselves. And we have responsibility to hold our own field accountable. Our partners, our colleagues, ourselves, and also those who sit on the bench, those who are making those decisions. So I'm very happy to, we'll be walking through this panel, and there'll be opening remarks by our panelists. We'll have some questions that I will be throwing to them because I'm just taking the opportunity to get in a few that have been on the top of my mind and many of my colleagues at Open Society Foundations. And then we're going to be opening it up to questions from you all. So if you did receive a card that was passed out at your registration, or you may have seen in the fellowship space, please, I invite you to use it. There will be microphones passed during the Q&A session that will follow this panel, but we know not everyone will have their opportunity to have their question answered, and the questions are really the juice of what we're working through. They raise the level and the standards at which we can pursue this action. And it also gives us an opportunity, if you're comfortable, of sharing your contacts so we can continue these conversations further beyond this evening. Not everything can be covered by us this evening, so we look forward to your participation in that way. I do also want to note that I failed to at the beginning that this event is recorded. It is not live streamed, but it will be recorded, and we will find ways that it can be made available to the participants, and it will definitely be available through our partners in identifying how they will make best use of sharing what's been stated this evening. So for those of you not comfortable being recorded, we also encourage you to have your question passed up by the cards, and you can ask your question anonymously, or you can be cited. Thank you for that. So, I wanted to turn to our first presenter on the panelist, who you've already heard a little bit about the amazing work that she has been doing. Karina Torres is an international law expert who specialized in gender, transitional justice, and colonial crimes. She teaches on human rights enforcement at Humboldt University and colonial theory and practice at, I actually don't know how to pronounce this. Is it Bucharest? Bucharest, thank you, law school. Since September 2022, she's been advising the Namibian law firm that Patrick Houta co-directs and the affected communities of the Ova Herrera and Nama in a long-term legal intervention for reparations. Prior to that, she directed the Institute for Legal Intervention at the European Center for Constitutional and Human Rights, one of our co-sponsors of this event. And from 2017, that was from 2017 to 2023. From 2009 to 2019, she co-directed the Humboldt Law Clinic, Fundamental and Human Rights, and she was teaching and supervising its practice-based projects focused on gender, colonial crimes, and business and human rights. She's been a research assistant at the Chair of Public Law and Gender Studies with Professor Dr. Susan Baer at Humboldt University. And if you note that there are the QR codes throughout the space for you to access digital resources available to you in continuing these conversations in your own research, many of the contributions have been from Karina. She is a proactive writer in ensuring that she raises these questions to how we can move from the philosophy into practice. She's an incredible scholar in intertemporal law, as well as challenging colonial era crimes and wrongs. Many of her pieces, as I stated, can be available, and she has a forthcoming piece very excited about that we should all pay attention to, that is entitled Minimum Legal Standards in Reparation Processes for Colonial Crimes, the Case of Namibia and Germany. So you know, you got it all here. There's incredible resources for us to consider how to apply the domestic, how the international and the regional advocacy is really complementing and working in integration with the domestic strategy that we've just heard from today. So I'm going to turn it over to you, Karina. Thank you so much. Oh, yes, and feel free to.
Yeah, also my side, many thanks, Gretchen, for this kind introduction, and also to the organizers of the event, especially also my thanks to Nora Henter, because it was really amazing the patience she had with us. As Patrick already said, the legal intervention that he has described contains several actions, amongst others domestic litigations, but also United Nations proceedings, for instance, the involvement of the special rapporteurs. I will now proceed to give a little bit more of an overview, a brief overview of our legal arguments with regard to international law. And yes, I'm really happy to go into details later during the Q&A, or we are happy to provide more details. But now I really want to keep the time of 5 to 8 minutes and will only give a brief overview. Well, the legal arguments in international law, I would say, cover three topics. The first of all is, of course, participation rights, and the special rapporteurs were very clear that participation rights have been violated, that there was a lack of direct and meaningful participation, and no self-elected representatives. The German government often says that it is actually the Namibian government who has to take care of that, and that the Namibian government is the only representative, the only negotiation partner, and the special rapporteur made it very clear that the Ovaherero and Nama have a legal position of their own. As I said, happy to go more into details later. Then the second point that Patrick already mentioned, and which is really outrageous, I think this is the point that makes us move on. That is like the thing that really causes outrage, I would say, is this reproduction of Eurocentrism and colonial racism by the German government, and accepted to a certain extent, as Patrick already described, by the Namibian government. We think that it is not only a reproduction of colonial racism and Eurocentrism, but that it actually amounts to a new act of racism. I will describe a little bit more what we mean with that. In a nutshell, as Patrick described, the legal position of the German government relies heavily on several premises, or let's say assumptions, which, like for instance, the universality of European international law, but also the lack of legal subjectivity and this horrible distinction between civilized and uncivilized nations, that was the foundation, or let's say the founding legitimation for the violence that was deplored during colonialism. Once you really add a decolonial perspective to this German legal position, and once you really go into thorough legal historical research, then this whole legal position of the German government falls apart like a card of houses when the wind comes, really. And that is in a certain way nice to see, I have to say, because as Patrick was saying, I think we really are in a very, very good moment to push ahead and to bring this down, because I think all of us know that this legal position is not, how do I say it in English, not sustainable. It will not survive the next 20 years. What exactly do we argue against the legal position of the German government? Well, first of all, the German government acts as if the European international law always had been universal, right? Very Eurocentric point of view. Because if you really go into legal historical research, you find the fact that before the European international law became universal, there was a pluralistic legal order. So how can you say that you determine the laws that were in force at the time according to the doctrine of intertemporal law, and then you do not even do the right research? I mean, they never said anything about the polycentric legal order. Why not? They simply omit it. First point. They do not only omit the existence of the polycentric legal order, they never quote any sources, legal sources, that are non-European. Matthias Goldmann, a legal scholar, made it very clear. We need pluralistic approaches, we need decolonial approaches. So where are the letters written by Hendrik Witbooi? Where are the letters written by Maharero? Where are the legal sources of the humanitarian laws and laws of wars of Ovaherero and Nama? Omitted. That's Eurocentric. That's a reproduction of colonial racism. That's a reproduction of the original exclusion, not only of the legal subjects, but also of their laws, their cultures, their knowledges. Thirdly, even if one took into account only the European legal scholars that the German government says it is taking as prevailing opinion, once you go into thorough legal historical research, you find out that all of this is actually much more controversial than the German government presumes. And this concerns legal subjectivity, it concerns the criteria, the distinction of civilized and uncivilized, for instance. But it also concerns the minimum legal protection. Because once you really go into the sources, for instance, Bluntschli, one of the big legal scholars, and you really read those texts, then you see that not even him, who of course was to a certain extent racist, because otherwise his texts wouldn't have been able to be published back then. But even him, in his writings, grants minimum legal protection. So what we see is that there was most probably a difference between what they were writing in their legal texts, saying, okay, even the uncivilized have a minimum legal protection, and then the fact that actually they didn't want to comply with those legal norms. Let me just quote Lothar von Trotha at this point in time. He said, wars in Africa, beginning of 20th century, he said, wars in Africa cannot solely be waged according to the Geneva Conventions. So let me ask you a question. If he really thought that no international laws applied, where does this quote come from? But if some of them thought that minimum legal protection existed, and Lothar von Trotha was talking about the Geneva Conventions, but decided, out of a position of power, to not comply to them, that nevertheless consists being a breach of law. So the only thing we are saying is that once you dig deeper, you find ambiguities and you find things that are much more controversial than the German government says. Last point. I can't see it anymore. Last point we want to make is the following. If the German government and the scientific service of the Bundestag, as Patrick already described, actually retrospectively reconstruct a prevailing opinion of the European legal scholars that if you really apply the doctrine of intertemporal law and go back and try to determine the laws at the time, was not as racist as the German government today assumes and concludes, then this retrospective reconstruction is today an act of racism that might be a case of racial discrimination in terms of Article 2 ICCPR and CERD. So what we are going to is really to make visible and to deconstruct the colonial racism, the Eurocentrism that is still embedded in international law. And that is what Patrick also said is this whole legal intervention about. I leave it here, and as we said, we're happy to respond to questions in details. Many, many thanks for your interest.
Thank you so much, Karina. Our next speaker is familiar to many of you as one of the leads of building this event, bringing this event together. Sarah Mani is a legal advisor and researcher with the European Center for Constitutional and Human Rights here in Berlin. where she focuses on German and European colonial crimes, as well as critical decolonial perspectives of the law. She's a German qualified lawyer and studied law at the Sorbonne in Paris and University Hamburg in Germany. She holds an LLM from New York University in USA, woohoo, and a master's in peace studies from Bradford University, UK. Thank you so much for joining us, Sarah. You can speak from either location you prefer.
Okay, perfect. Okay, great. Yeah. So just let me start to amplify again that reparations really is a movement, and so is preparing for reparations, litigating reparations, a collective effort. So I here really want to acknowledge the work of my colleagues Judith Hackmark in particular, Leocadia Melchior, and Dr. Evelyn Campens on restitution. So what we do when we prepare for litigating reparations and restitution in particular? We look into norms, especially first of all into international norms that have a decolonial potential, and there are quite a few. So I don't have that much time to name them all, but for instance, if you look at the United Nations declarations of the rights of indigenous people, the participation rights, Patrick and Karina were talking about, find their roots in this exact declaration. They are customary international law. It's like everything, obviously, in this area is contested, but I think you can make great arguments for the nature of customary international law of these rights. And so now, and it's interesting actually, what we do is really to try to bring into these, these arguments, these legal arguments, into the public discourse to build references. This is exactly what the work with the special rapporteurs, submissions to UN special mechanisms does. We have references we can work with. And, that was the super surprise last Friday, Patzinger, the director of the infamous Humboldt Forum, he was quoting the UNDRIP. So it seems to be working. Let's see how that turns out. But obviously, human rights, they are implemented and enforced on the national level. We can't work on human rights and the human right to reparation and restitution without working in national jurisdictions. Hence, this is where really the challenges come in, and there are quite a few, but as I just briefly will be able to mention, we can overcome them. But first, we have to see what are the challenges. First of all, again, decolonization of law, of liberal law, of the state law, the law of the liberal state, obviously is quite difficult because there's a huge heritage in it that finds its roots exactly in those problematic legal sources that are quite limiting other forms on sources and systems of international law and law that could provide a human right to restitution, in particular reparation in general. So what we see, what is the first challenge, first of all, is really how to bring legal claims for restitution, and now I will focus on restitution, that are based on individual, liberal conception of rights, because those rights to restitution are mostly collective rights. And those are different rights of the liberal, very different to the liberal, to the hegemonic colonizer state. And this is the first step we have to bring forward. So how to litigate collective claims under liberal legal systems. Then again, and I think this is an issue that isn't talked about as much as it would be necessary, is really we need to decolonize procedural law. Because this is exactly, this is how to enforce law. It's nice to have this claim and to have the theory and all of that. But really where it's happening, it's in the court, it's in the trenches. And this is where procedural law comes in. So what we are thinking or trying to figure out is how to, obviously, especially if you think about the restitution and the problem of provenance research and who holds sort of the power over the knowledge and the information about the origins and what happens to those objects, the ancestors, human remains. I want to also mention that problematic. So the knowledge is with these institutions. And these institutions, though they are making these claims, like they're decolonizing the archives and stuff, it's just in the beginning, and it's just thanks to academics that this is happening and not from within the institutions as much as it should be the way they are claiming that they are doing it. So we need to think about like how to achieve, for instance, a reversal of a burden of proof in administrative law, which is super difficult jurisprudentially based on case law, but we are researching, and again, thanks to collective efforts, we probably could be successful in like doing so. So that is procedural law. Now to the legal claims. Obviously, it's wonderful to have these wonderful and very important conventions, customary international law, human rights treaties, but again, how to enforce them, and this is under the constitution of especially the colonizer state, because this is legal bindingness at its best, so to speak. So what we do, and here I think the challenges are a little bit different when it comes to the restitution of human remains and ancestors, and the restitution of artifacts in particular. So first of all, for the human remains, I mean, there's a post-mortal right to human dignity under Article 1.2 of the basic law, the German Constitution. Hello. And then, obviously, and this is just one legal basis, but in given time, I will focus now on the restitution of artifacts. Chief Taku, and then I hand over to you, is obviously we have a right to our cultural identity as a general right of our personality. And you could achieve that through interpretation, through international law-friendly interpretation in accordance with the principle of the Constitution, in using exactly the same covenants, like the right to culture under Article 15 of the ICE-SCR, together with these issuance, like the general comments by human rights bodies. This is, again, interpretive tools and methods. And then the UNDRIP. And Article 11 and 12, they clearly state a right to restitution. With all the intricacies, I leave aside for the moment, but I think you could argue that there is a limitation of discretion on the side of the state, whether they want to grant just access or restitution, when it's especially important, especially spiritual objects of very high spiritual importance. Let me close, and then I hand over to you. Really, culture is the essence of being human, so we need a human right to reparation and restitution.
Thank you so much, Sarah. I feel like you unpacked a lot there that I'm certain that there will be follow-up questions on. Thank you so much, particularly the breakdown, which will be helpful for many to understand the distinctions between these different forms of reparations and how we can start including within our language some precision as to what restitution really looks like. So thank you for that. I'm very honored to introduce our next panelist, Chief Charles Taku. He's a leading, yes, sir? Has there been a name change since? I'm just joking here. I'm really excited to have you speak with us. You're a leading international law expert before international courts, tribunals, dispute settlements, and adjudicatory bodies. Chief Taku is an expert legal practitioner. He's extensive experience advising and representing states, international organizations, and multinational corporations. Chief Taku is a distinguished author and mentor, and has just produced a paper he's presenting before the African Bar Association this fall, entitled In Search of Justice for Victims of Colonial Crimes. So we can look forward to that being available to the public in short order. And he speaks much of the voice as both an expert, a legal expert, but also in his role as a generational victim. He brings a perspective on reparations and the very unbalanced scales of justice, which we are working within. Thank you so much, Chief Taku.
My time is very, very limited. I'm very time conscious. but permit me to thank other organizers because on the 17th of March 1991, myself, Chief M.K.O. Abiola, and others were in Sheraton Hotel in Abuja to launch the movement for reparations. Chief Abiola died and we're in the wilderness. Thank you for giving me the platform and the voice once more to speak to the world through this platform, and more importantly in Berlin, where the partition of Africa occurred. It is very, very symbolic and important. But I'm also the grandson of Fontema Songanyi, the king of the Banwas, and therefore, I'm also a traditional chief there, the Banwas. I speak for myself and millions in Africa of affected groups of people. And I want to say very, very clearly, where I oppose very vehemently the question of Germany and other countries trying to interpose the neo-colonial states with the affected communities in Africa that suffer the wrong. It is against international law. It is against natural justice. It is immoral. Indeed, it is also a glorification of the crimes for which solutions are sought. That said, I have been engaged in trying to the restitution of the Banwa colonial arts. The last speaker, Sarah, is our lawyer, and of course we have Isabella Boza, who is here, and Evelyn Confen, who is not here, but she is in Amsterdam. My mandate is worldwide because the proliferation of the Banwa arts is worldwide. We find them, the Banwa Queen in Paris, in the Metropolitan Museum in the US and Amsterdam, and also in Holland. Now, let me say quickly what I've done. First, I'm a lawyer for the government of Burundi, and I helped in amending the Peace and Reconciliation Act in Burundi to give a robust mandate to go after Belgium for the colonial crimes. And therefore, there's a commission in Belgium, parliamentary commission now, deliberating on the question of reparations for victims and affected community in Rwanda and Burundi and the Democratic Republic of Congo. But I'm here in this room as a client, as a simple person, because I have lawyers and as a lawyer, I respect other lawyers. But let me say one thing, that must be done. You must hold them accountable, they must accept the crimes. The Lord Mayor of Brunswick wrote to me, accepting, the loss of the Banwa objects took place against a violent colonial background. The suffering you described is almost impossible to capture in words. I deeply regret the crimes that were done to your people. I'm very pleased that we can now reflect together in dialogue on the misdeeds of the colonial period that were so painful for your people, and that we can also talk about possible restitution claims. I thank you for your willingness to engage in dialogue. Thereafter, I was invited by the municipal government of Cologne, and we came with a delegation. And today, I'm happy to say, with my lawyer and Isabella, we're with the Ethnological Museum in Berlin for the first time, after I've tried for several years. They received me today on this matter. Secondly, and let me not take much of your time, the question of reparation is crystallized in international law and international customary law. The Permanent Court of International Justice in the Chozos factory case held that it is a principle of international law that the breach of engagement involves an obligation to make a reparation in adequate form. And you all know, with regard to the Banwas and many other victims and affected communities in Africa, that in 1899, when 26 countries in Europe were laying the basis for international law and laying the basis of the Hague Conventions for the protection of cultural works for all people, they say all people, that's when they looted and stole the Banwa artifacts, and that of many of the victims you know, looted them, killed, forced labor, and they've omitted in the colonial record. As they talk about Les Femmes, they did not know what is Les Femmes until the research proof that Les Femmes is the center of Banwa humanity. It is the center, the very conscience of African civilization and our spirituality. And we became the only people in the world, the only race in the world that glorify God, not in our own images, as even the Holy Bible says, by the image of other. This is caused by these crimes for which you have given all this platform to fight collectively. And to empathize with Patrick, what he said with Namibia, it's extremely offensive. And I think it's something that must not occur. The world must rise as one. In here, I've seen so many other people who have been fighting. You've sacrificed all your time, and I really honor your level, and I thank you so much, Open Society, Human Rights Watch, European Center for Constitutional Human Rights, and everybody involved in this. Now, there are principles, just to complete, the principles for reparations, basic principles and guidelines of the right to a remedy and reparation for victims of gross violations of international human rights law and serious violation of international humanitarian law. Article 6, 7, 12, they say that the statute of limitation shall not apply to gross violations. This is not enforceable per se, but many of your resolutions, UN resolutions, have crystallized into customary law. They become erga omnes obligations applicable to all countries in the world. Germany itself, the Treaty of Versailles, Article 122, Germany paid reparations, the late reparations they paid. And Germany has signed so many other conventions of late that in the course of war and committing a crime, they will restitute. And that's why, what did we do? What happened to Iraq and Kuwait that they pay reparations? And of late, America had to pay reparations and restitute after they were stolen by American soldiers. What did we do that they cannot hold us to the same standard? I asked the question today, let me ask before I sit down, with your permission. I asked the question that I was sitting here, Mr. Director, and you're showing a lot of respect for me, probably because I'm an international lawyer, appearing in international court and tribunals for the past 25 years in a 40 years career. And I ask, but what will you say that I sit here talking with you with all due respect? In the next room, the very symbol of my cultural identity, of my spirituality, the very conscience of my civilization, and the creative ingenuity of my ancestors is being showcased to the world. That is a war from some savage, price of war, some savages that less than human, we're not responsible for it, while at the same time you are gaining profit from it in order to make money and buy the next weapons to send back to the very communities to kill each other. How do you feel when this occurs? Thank you. I'll leave you with that question.
Thank you. Thank you. That is a question we'd love to hear comments and responses to, as to how we feel. What does it mean to take personal action? Reparations exists in every frame, I know. One of my teachers always stated, as people are arguing, well, what's the first and the best way for us to pursue and satisfy a claim for reparations? And the response was, we need to pursue as many avenues to satisfy reparations as the number of avenues in which we have been oppressed, in ways in which crimes against humanity have been perpetuated. And one is just in our personal action. Many being in a very complicated space as to what it means to enter these spaces, where people's lives, their faith, the medicine and safety has been stolen, plundered, and then put up for exhibition. What are the choices that we make, and what are the choices that we make with all of our, as we move forward, and how we speak about these representations and the exhibitions. So thank you for that very personal question and charge for all of us to really reflect on. Thank you very much. And so I'd love to turn to the rest of our panelists, as well as Patrick, with a few questions that have arisen from your work, and I know that you put a lot of thought into it. And I will actually start with you, Chief Taku. I'd love to hear a bit more. I know you're doing quite a bit of work on resourcing local attorneys. You spoke to the need and the demand, and many of the other panelists did, of domestic legal action. that it does not have to all happen at the international level, but even if it does, there's a lot of resource and support that's needed for attorneys in former or currently colonized states to be able to lead and step forward in this new decolonizing of the law and pursuing cases. What are the types of resources you've been asking for to help build the new generation of lawyers who are hopefully going to be pursuing these actions?
Well, let me say something very, very clearly with regard to this particular case of Namibia, Cameroon, Tanzania, Rwanda, and others. They may say that we're not subject of international law, far from the truth, because we're mandate territories and became trust territories under Article 76 of the UN Charter. And the US and international communities should strongly support these claims. You must establish, first of all, the victim, the people who suffer, the communities, the people to whom we belong. And that's why I oppose the new colonial state interposing between them and the people who actually suffered. But let me say with the new generation of lawyers, this area of law has moved, crystallized to the forefront of international justice because it numbs the conscience of humanity. That there are people who are still there holding upon things that they looted and stole. I saw a king the other day wearing a crown of diamond and other things that do not belong to him. And if I've gone to a church, I went there and saw things that were looted on the blood of people. And I tell these people, look, let's join this movement. I can say I'm a newcomer because I was not a practitioner there. And I'm taking everybody along. You just talk about the Pan-African lawyers in Zambia conference. I'm going to South Africa on the 5th of August for the African Bar Association to talk to many young lawyers. And Sarah, Isabella, and Evelyn invited them to talk to African lawyers in Niger, in the heart of Africa, and in Malawi, and were fully mobilized. And I can tell you the only obstacle we seem to face now, if we were just these colonial people, the perpetrators of the crimes, who will prevail? It is a new colonial state. And I do not see a situation where a defendant, perpetrators now, tries to impose whom to talk to. How do they prove harm and prejudice? How do they? It is those communities. But also the question of satisfaction, the question of giving back their humanity and their dignity. It can't be these politicians and this in the new colonial state. So I tell the young lawyers every day, and there's so many of them, I tell them every day, join the fight. And I'm happy that Open Society, Human Rights Watch, European Center for Constitutional Human Rights, and individuals, some of them are found here, I've read about them, are giving them this platform and a voice. Let them come on board. Please, when we knock the door, open for us, because you've taken us this far. I wrote to the museum for over, 5 years. They did not dignify even me with a reply. By the moment I brought the European Center for Human Rights, she wrote once, and the next day I was surprised to receive a reply. And this is what the power of your organizations. I find you in the courtroom, international criminal justice, humanitarian law, under different circumstances. I find your reporters and others there every day. But I didn't quite know that you were involved here. And I meet Human Rights Watch every time, either in the International Criminal Tribunal of Rwanda or Sierra Leone, or the case of Darfur, Center for Republic, all the cases in which I'm lead counsel. I work with them in the field. They're first responders. I did not also know that you are first responders also in this particular case. And the profile is very, very, very high now. The world is paying attention. And therefore, please, you should help us and help the young lawyers. We do not have the resources, many of them, in order to come this far to organize in our own case. But I know very well that with your experience and with your distinguished and acknowledged performance and assistance to the underprivileged in the world and the people who are being humiliated, the humiliation of even seeing this displayed there is so much for me. And in other words, going to the new colonial state, take note, it raises the question of ethnicity. And the question of ethnicity is responsible for many of the wars and the genocide in Africa. And when they hand over the area to the new colonial state, they create another layer of victimization so that it will never reach the victims or the affected communities. Let me use the appropriate word that one of our people told me. Thank you so much.
You can keep that. Thank you very much. Thank you, Chief Tackle. Turning to Sarah, you've been you've been working on these issues for some time, and I really appreciate your transparency in needing to develop a strategy and how you're developing a strategy that is going to anticipate the many different arenas and the pathways in which the German government is responding to claims and in which your clients are seeking remedies. I'd love you to share a little bit more about when do you think is the right time even for lawyers to think about and preparing a litigation strategy when so much, particularly with work on restitution and repatriation, is so much as held in diplomatic relations, political negotiations, even when cases do make it to court, as in the case of Namibia and Germany, results in state negotiations. I'd love to hear what your recommendation is for us. When should we start preparing?
Obviously, difficult questions. The difficult question, we've been talking about that a little bit, I remember. So first of all, let me start. Obviously, in the center of all of that are the wishes and demands of the communities. And hence, it's very important to have the mandate to talk to them, to listen, first and foremost. And then, present the different strategies that are always transnational. They are always building on networks, on collective networks, interdisciplinary networks, especially relevant for litigating colonial crimes and reparations. Obviously, we can't do it without the historians, the art historians, the provenance researchers. We would be lost in translation, really. And so that is very central. It's adaptive, it's multi-leveled. As I was saying, you have to build your own sort of reference points. And then, be prepared. And this is really hard with these really complex cases that have a very, obviously a historical legacy, and where the law, it's both. It's a lot of complex factual research, but also, obviously also, how to move decolonial legal theory into decolonial legal praxis. So it's a lot of doctrinal research, but also exchanges and listening and learning from experts, academics. Yes, I think that is that. And also, when is the time to react? I mean, it's because it's so much going on right now in the area of reparations and restitution. It's sort of everywhere. So it's shifting all the time. So for instance, in Tanzania, we were ready to litigate. We were in contact with communities. They were ready also to litigate. And then, the negotiations started. And then also their wishes shifted, and they thought, okay, there is maybe a window of opportunity, a chance for us to get involved. And then our strategy shifts. The legal arguments remain the same, so the preparations of that is never lost. So participation rights obviously can be litigated, but also can be fed into interstate negotiations. And for us, really the motto in that regard to Tanzania is really because the processes are starting. So we are saying no Namibia 2.0. So we have the chance, the German government really has the chance to redeem itself. And we are in contact and consultation with stakeholders, and we hope to feed that legal argumentation into that. But at the other time, we are ready also to litigate if it's necessary.
Thank you. Can I ask for a follow-up question on that? I mean, you're saying you're ready, folks ready. How hard is it to convince non-lawyers to integrate a litigation strategy? Have you found it difficult? Have you found folks are begging for you? I mean, absolutely with your work, you are centering and responding to the needs of the community. But as to the others you need to bring on board or work in collaboration with, if you can name a couple challenges that you've experienced or some surprisingly positive responses you've experienced in investigating and preparing potential litigation.
Again, I think, like I can really, because that was the last bigger, really huge project, the Tanzanian project. First of all, for many of the people I talked to, for them it was so intriguing to see that it's about their rights. It's not about their government talking to the other government, and hence saying, oh wow, there's potential, like even in the former colonizing state, to get my right through, and even to have that in a public discourse. That was really, I didn't need to do a lot of convincing. Yeah, I think that is, I would say, for the rest, I leave it at that.
Well, thank you.
Okay.
Thank you. Karina, if I could turn to you. I appreciate that you gave us even just a little snapshot of the tremendous amount of scholarship that you have committed to the topic of decolonizing this area of the law, or actually just law, human rights law, more broadly. And I'd love for you to share a bit more. I know you've written a bit on the positive obligations states and the governments that are parties to these UN treaties. What are the positive obligations they have to decolonize the law itself? That there is some misunderstanding that it is static, and also misunderstanding as to who bears the burden on advancing and protecting and respecting satisfying reparations. I'd love to hear your perspective on on ways to think about that outside of just the burden is on the survivors to pursue this.
Yeah, many thanks for that question. It is a really, really tricky one because I think we're here back in the whole question of decolonization. Famous prominent decolonial thinkers have shown that right after formal independence, several states of the global south have really tried, for instance, to decolonize the international economic and trade order, and have tried for several decades, and have tried to do it through the United Nations and has not really been successful for several reasons that I cannot go into detail here right now. Of course, there are some legal obligations also contained within the human rights instruments and in customary international law directed towards states to decolonize and to tackle and to overcome the racism that during colonization has been inscribed into law. For instance, the United Nations Declaration on Indigenous People, Article 11 and Article 18, which are clearly an evolution beyond the state-centered approach of international law, clearly. Then we have the right to self-determination, and of course we have the right to tackle and to overcome racist patterns in third. Nevertheless, I do not really think that it will be the states currently who will be pushing for that. I really do think that these struggles will be legal struggles that will be pushed for from the bottom up, surely. I think that is all I can say. Patrick, do you want to add something to that? No, that's all then.
I just wanted it on the record. Right? Absolutely, absolutely. That there's an obligation, but a whole lot. There's been a lot of patience with seeing them step up to that obligation and not necessarily allowing for the access to really jurisdiction is to pursue it. Thank you so much. Patrick, thank you so much for what you shared with us, particularly in your action in Namibia. And it's just such I think it's this brilliant strategy. The more I read what you all have been filing, as how the Over Herrera and Nama people are elevating a right that is oftentimes overlooked, the right to participation. And how that lives in many treaties, it lives across the board, and how right to participation in and of itself is a form of repair, but it is also just a basic procedural, as you stated, element that is often overlooked by attorneys themselves. There's many critiques as to how the litigation that led to the joint settlement resulted in the lack and the exclusion of the communities that are most impacted by it. I'd love for you to just share a bit more on where do you see the right of participation? Do you see that evolving? Are there more, beyond understanding that the law that you're noting is that of national law in Namibia and the Constitution, it's reflected elsewhere, and particularly with the ICC. And I'd love to hear what you feel is the future of the right to participation. Is it expanding? Are there more tribunals around the globe recognizing and resourcing the survivors to participate in, to be heard, and to advance their right to repair without having to be witnesses for the prosecution?
You're asking tough questions, but I think, and rightly so. Look, I mean, you said immigration, and right at the beginning, you said a very interesting statement that law follows culture. And one of the biggest problems about lawyers, especially those of us in practice, is that we are conservative in thinking and outlook initially, in the sense that most courts, whether it's Namibian courts or German courts or US courts, will not really give you justice because of procedural rights only, unless you are in the realm of administrative law. In constitutional law, particularly, the procedural rights themselves will not give you any remedy unless you couple it to some substantive right. That being said, the good thing about participation rights in our case, and in most of these cases, is that lack of participation is coupled to the substantive right in this way. If states negotiate themselves, as it has happened in Germany, and the negotiations are carried out by state actors, unelected officials, you find the difficulty in a sense that they are not true representatives of the people. Because in any democracy you have three organs of state: the executive, the judiciary, and parliament. And the true representatives of the people are really the parliamentary forum. It can never be the executive, as it has happened, because ministers in most countries are appointed by and serve at the behest of the president, not necessarily as elected officials who are in parliament. So in our case, participation rights, we were able to craft the argument that says that not only have you violated a procedural right, you lack essentially a mandate to conclude any sort of an agreement with others and with the other side. So I think, speaking and bringing it more closer to our scenario, we were able to, and are able to fashion that right through UN instruments on that basis and attach a remedy to it that effectively the negotiations are nothing else but a sham because there's no mandate.
Thank you. Thank you for that. I have, as you all see, a lot more questions. But we want to be able to make space for you all to have your questions answered as well. Before we do that, I'm going to do a quick fire round of a few questions for you all to answer, but just preparing you all that y'all are going to be on next. And so here are my quick fire round of questions. I'll go with a couple sentences from each of you down the line, and we'll have a few. So the first question is, what keeps you going every week? What keeps you going and gives you the most hope about this work? Chief Fataku?
As I said, I've been litigating in international courts some of the most serious crimes, like genocide in Rwanda, the Special Court for Sierra Leone, in Darfur, now the Council of Darfur, Central Africa. And I know exactly when I see people who are affected by international crimes. And I confess to my friends every day that in that courtroom, the most powerful person is the witness, especially a witness of rape, where the woman says exactly, I was raped in the course of war. And she gives her testimony, and they ask you, cross-examine her, and she turns and looks at you in the eyes. If you are not careful, you will have violated her several times, and she will never forgive you. She might forgive the people who were there in the battlefields. So I know the pain that these people suffer. I've seen exactly what the devastation of the colonial crimes in my own community. The children, you can get there and see them. And I can see the systemic nature of the crimes in the society in America, systemic racism or whatnot. You are confronted every day when you get to a place and you say, oh, they may put the next gun on me because of whom I am. I could be the one, but I'm already the one because it's my great-grandfather. But I've seen many others. I just heard the case of Namibia. It is one of the most offensive stories I've heard today. How the state, in other words, they use proxies. The people are called the new colonial state in order to victimize their own people and humiliate them. We lost, in fact, what keeps me going is to try to see how I can fight to bring back our lost, stolen humanity. And on a day-to-day basis, when I go to bed, I think about that. When I'm over there, I think about that. And I think I have a mission. My late great-grandfather fought for 9 years before the Germans could imprison him and condemn him. After 123 years, I became the first person to even lay my hands to see some of his property. And I think, to summarize it, I would say sometimes, this legacy belongs to people. Many of them dead, many alive, and many unborn. And therefore, I have a mission to pass to the next generation. If I fail, the next generation will succeed.
Thank you. Thank you for that. You may keep that. Thank you. Sarah, this is not easy work. What keeps you going week to week?
I mean, it sounds generic, but it's not, for that, it's not less true. It's a fight for the people, it's a work with the people, and it's an understanding and loving and understanding husband and family. But nonetheless, like, seriously now, it's about, I really believe in international law from below, to quote Rajagopal, and I think that is even more so important in the case for, like, the fight against racism, the fight for reparations, and the fight against structural violence, which is the colonial injustices, and they are on the basis of it.
Thank you. Thank you. Karina.
Yeah, you said you wanted to have a short answer, so I will try to do my best. What keeps me going every week? Well, sometimes I do not know anymore because it's a difficult topic we are dealing with, and it's a lot of violence one confronts, as Chief Taku also said. But I think it might be a certain idealism that I think got from my father that keeps me going, and also I think the lack of another possibility, because I really do think that urgently, perhaps today, I mean, it's always urgent, but urgently I think we all together have to build a future in which structural hierarchies, dominations such as racism, gender-based violence, etc., have been overcome, and in a future in which we can really talk about how we want to distribute the wealth we have. So I think it is a lack of a better option and an urgency that keeps me going. But yeah.
Thank you.
What keeps me going, really? I'm a descendant from the Ovaherero people. So most Ovaherero people my age do not know where their great-great-grandfathers or mothers are buried. That applies to me. From my maternal side, I don't even know who he was. All I know is that my grandfather from the maternal side, his father was a German soldier. But so one wants to leave an impact. I mean, as you have said, I have practiced and I continue practicing in other more lucrative areas of law. But what really keeps me going is my son and my family when they say, what would you say you have done on the face of this earth rather than acquiring material property without having a real impact to your communities first and to your nation at large. And I think that's what keeps me going. And the opportunity to change views that one has, I think that really keeps me going.
Thank you. Thank you. So I now turn to you and some of our colleagues in our room. I want Kimberly and Kim to please raise your hands. They are going to be circling around with microphones, holding on to those microphones as you speak. And in addition, it's Britta? here, the hand raised. So if you want to pass cards up, you can either hand them to Kim or Kimberly. Ultimately, those cards will go over to Britta, and she'll be passing those up as well. So if anyone wants to raise your hand if you have a question. Thank you.
Hello. Can
Hello.
you hear me? My name is Bojan Gavrilovic. I'm a human rights lawyer, and I'm really passionate about reparations. I'm working actually on reparations for crimes of, for ISIS genocide in Iraq. So it's a recent crime, but we are facing many, many obstacles that survivors can really realize there are to reparations. And I also am following the story about the genocide against Herero peoples. And as a lawyer, I really understand the legal arguments very well, and I understand the problems with jurisdiction of bringing cases to court, the sovereign immunity of states. So this is really a problem, because then you cannot even deal with this uncivilized people's argument, because you will be refused at the application phase, right? So my question, and I'm coming to the question now, this argument is really horrendous, that these people have no rights and we can do whatever we can, and they're using it again. And I'm wondering, can this be a part of a bigger media campaign in Germany? Because in Germany, they're really sensitive about this. And if there is a campaign shaming this argument, and how is this in line with feminist foreign policy, for example, that can make a change. And maybe parallel, there can be legal avenues. And I agree, maybe in 10, 20 years, there could be a change. But these people, they need solution now, not in 20 years. Thank you very much.
Thank you. Thank you. Do any of our panelists wish to, is there someone who first wants to be able to respond to that? How are you using media and the narrative? How has shifting the narrative become a part of your strategy?
I think we try. So what we do is we speak to, I think to some media houses here in Germany, Zeit, what is the other one? In fact, we also spoke to the Frankfurter, we also spoke to the Guardian, yeah. So I think that's what we do. I mean, like tomorrow, we are also again engaged in media work to try and bring awareness, especially on the harsh German position. But we can only do so much. I think we agree with you. We need more hands on wheels, especially with respect to these newspapers, the media houses in Germany.
Thank you. Absolutely, thank you.
Yeah, many thanks, and perhaps from a German perspective as well. I mean, the Ova Herero and Nama have been struggling for decades now, right? And they have also been working very closely together with a huge network of civil society actors. Reinhard Kössler, for instance, whom I have seen, who has been working on the topic for decades as well. So there has been a lot of work going on also from civil society in making this whole cause and the political demands more visible. And I think those arguments, especially the legal ones, they are now more and more fed into the discussion, into the debates. So I would say it's not really a lack of putting the arguments in, it's rather what Jürgen Zimmerer and others call a colonial amnesia, that it's very, very difficult to for some people in Germany to want to hear. And you find the same thing with actually the Foreign Office, because the Foreign Office, I mean, they are reading facts, they know about the legal arguments, they have received the letter, the joint communication by the special rapporteurs, and still somehow, because desperately they want to hold on to this old position and not face truth. They just continue with their own arguments and continue in their own mindset. But just to add, it's media work, of course, but there is other people as well involved and strongly involved.
Thank you.
May I just add to
Yes.
that, which is a really quick reference, actually, because I think, yes, obviously the media plays a very important role, but I think also the arts and organizations like Forensic Architecture, and you're there, making like the harm and actually the factual background of, for instance, the genocide in Namibia tangible through other means, and in that open up, in a way, they're opening up the public, and it's through the tangibility of what's going on. And Ashkan probably could expand so much on it. There is a great article in the Spiegel on the forensic architecture's work on Namibia, and there was obviously the big event last year. But yes, I think that also is it's not only the media, but it's different interventions, artistic, and so forth. So.
Yeah, if I can just say one word. The key issue here is about getting the affected communities and the rest of the world to know the narrative. The voices of the people in the affected communities completely mute. They are considered as non-existent, inconsequential. But the media can play a major role. In the neo-colonial states that they rely on have shut the archives, even to the affected community. So the lawyers looking for evidence, even from the colonial record back in the neo-colonial state, in their position, have difficulties. They wouldn't give you access to that. And they put all sorts of obstacles. But it is for us to go there. When I came here to Cologne and to Berkeley, I was surprised that Open Society representative in Dakar, he heard about that we're coming, and he was there on the spot waiting. The television from Japan, the journalists from Japan were there to interview me. There were also other journalists. A year after when I attended the Nuremberg Principles, I saw so many participants. We saw you on the German television talking about this. And I can tell you why I say this platform is important, and also the media. It's because the affected communities must be given, and there must be some confederacy between different communities. My community would like to know what is happening in Namibia, and possibly we take their case to the rest of the world, because Namibia succeeds, we succeed. In fact, it is because of Namibia that they now told to refer our case to the neo-colonial state. It is because of the litigation. What happens with the case in Namibia affects many other cases in here. So it is good that the media, we should involve the media on this as much as possible. They have the capacity, they have written a narrative which they impose and brainwash everyone to accept, and they have the diplomatic channels. We have nothing but ourselves and probably the media, and of course, Human Rights Watch, Open Society, European Focus on Human Rights, and many of the people here. But these are very limited resources, and we're relying on very few of you to provide the resources to help us to do this. So we should go out there and make sure that we get the media to get involved. I know, I'm not calling for mass action, but I also know that we can create the debate. Why is the African Union not talking about that? Yeah. If these people are really out for their own, why are they silent? Absolutely nothing. Why is the United Nations? It is only the lawyer there, good lawyers who are persistent enough. Many others are bullied out of the system, and many others don't have the resources. And the continuing crimes, I say these are continuing crimes. As long as they continue to benefit from the crimes and portray us as if we're not human beings or half human beings, and humiliate us, there are continuing crimes from generations. So we must be able to counter that narrative.
Thank you. And also noting that there are others in the room, you may want to speak with I mean, particularly, we're going to have Almaz up on the stage as our final charge as to where we can go after this with Human Rights Watch, but also the partners that Veronica and others work with SciSci, House of Fame, for example. I take the perspective that we don't need to lobby media, we need to be media, create media. And I think that that has been what much of the resourcing with Open Society Foundations has been as well. I think we have time for possibly 2 more questions. And please, I encourage all of you, particularly those who may be leaving early, to still pass up your cards if you want to have any contact with us following this event, because we promised to dump the registration list if for anything that's not associated with this program. So we would love to stay in contact with any of you. So I think we've got one right over there, sir. Yes. Thank you.
All right. Thank you. My name is Michael. I'm also a Herero from Namibia, currently living here in Europe. Now, I have just one question. It may be directed to Dr. Patrick and Karina also, if you may also answer that. But as we know, of course, you filed a case against the Joint Declaration, which was kind of acted on by the community members, and it looked much more like a collective effort. What do we see as the way forward after whatever pronouncements that come from this case against the Joint Declaration? Do you perhaps see the need of enforcing unity of purpose among the affected communities, as we know that there is, evident disunity among this affected community?
Anyone want to take a jump at that? Yes.
We are busy. I think one of the things that will unite people is a common purpose. And one of the things that we are seeing, and that's why we deliberately uses the word that we are acting for the Ovaherero and Nama, and not factions, is because we are acting for everyone in a sense that there is at least a common purpose with respect to the issue of reparations. Whichever side of the coin factions are, I think there's no debate about that. Even those Ovaherero leaders who initially collaborated with government have come out to say, well, these negotiations is not what we foresaw or contracted to. So I think there is a community of purpose there. What do we then foresee after we are, or while the case is ongoing? We have said in our medium-term goal that it is to have new negotiations based on the correct norms. And we see that really taking place through interparliamentary committees, both of the Bundestag and the Namibian Parliament. We see ultimate reparations. It's, I think it's either Sarah or Chief Taku who said it, that ultimately, I think it was Sarah who spoke about, when she spoke about norms, and that these issues will have to ultimately come out of a legislated position. Whatever negotiations, ultimately, in order for it to have proper effect to the affected communities, must be through legislation, one way or the other, or proclamation, or whatever one calls it. Thanks.
Thank you. Thank you. A question has been passed up to us. I was going to read out. It stated that we've considered, have any of our panelists really considered as a counter-argument that the ECHR uses in its jurisprudence standards from other international courts, such as the Inter-American Court of Human Rights? Is that in consideration, this forms of soft law? How do you take that into consideration with your work? Is there anyone who wishes to? Yes, sir.
This is one area, and I think what is occurring with our colleagues with the case of Namibia and possibly other cases is that in the human rights international treaty regime, you need to exhaust local remedies. And these local remedies can take various forms. And the jurisprudence is that you have also to demonstrate that the local remedy did not exist, or they were available but could not be obtained with reasonable diligence. And therefore, in order to go there, it's very, very easy with the case of Germany to go to the European Court for Human Rights, which decisions are binding. But you need to do a lot of litigation internally to exhaust local remedies. And they do everything to slow down, exhaust you. And in the African Court for Human Rights in Arusha, which decisions are binding, many African states have not signed the protocol giving individual mandate to individuals in order to bring. It's another court that can bring it, or the African Commission on Human Rights, or an organization that has observer status. Well, we will surmount those obstacles, but take note that I think my colleague dealing with the Namibia case are on the right course by exhausting local remedies here and there. And I think by the time they get to the multilateral treaty, the European Court of Human Rights, I think the defenses put up by Germany, the obstruction will collapse to the ground. I think they will give up by the time that you are ready to surmount these procedural hurdles to get to the European Court for Human Rights.
Thank you. Thank you for that.
Just really briefly,
yes.
very briefly,
Please,
because
Sarah,
I was Sarah, talking about the international law from below, and I think when you talk about reparations, obviously the Inter-American Court of Human Rights, it's like, hello, this, the court and the jurisprudence you have to look into. That's for sure. And what I think, and especially for reparations, for litigating, or achieving some sort of justice for colonial crimes, you have to look into, like, build even regional customary international law, and even that would be super interesting, actually. This is something I'm exploring a little bit, like how to look into transcontinental regional laws and how to think about new sources that could connect those strong case law, especially before the Inter-American Court of Human Rights. Thank you.
Thank you. Thank you. We are running short on time, and I know that that has definitely been my responsibility in preventing you all to be able to get some final little bit of food before it's going to be disappearing in 15 minutes. But I'd like to call onto the stage Almaz Taferru, and we're going to just have a final charge for you. We'd love to hear what the thoughts are the experts and the partners that we have here in the room. If you want to just take my seat, if you would. Oh, sure, yeah, no, please have a seat here. Thank you. And then we'll be, oh yes, and then we will be closing out with an additional charge from one of our partners with ECCHR, the director. But before we get to that, I really wanted to, yes, hear from each of you, another rapid fire. We'll start with Almaz. And before I do that, let me give you her background as to how much she has brought to this work. Almaz Tefera is a researcher on racism in Europe at Human Rights Watch, our partner and co-sponsor in this event. And she works on human rights implications of racism and discrimination based on racial, ethnic, and religious identity in the European Union and the United Kingdom. Almaz is also interested in the research on institutional and structural racism in Europe to address ongoing impacts and harms of colonial and slavery legacies that have been left by European countries. Her academic and professional backgrounds in various areas of international law, and she holds an LLM from Geneva Canopy for the International Human Rights and Humanitarian Law, as well as an LLB and LLM from Maastricht University. I'd love to turn to you, Almaz, and just there's so much that you have done in producing recent reports with Human Rights Watch that I'd love you to touch on, but also the work that you've shared with me on the efforts in joining and building a network of professionals who are addressing reparations. Do you mind sharing us with a bit with what is it you're doing to build on a network and what you'd ask of the folks here? What do you need from them going forward?
Yeah, can you hear me? Yes?
Yes.
Yeah, okay. First of all, it's such an honor for Human Rights Watch to be co-organizing and co-hosting this very important event. And I think the importance of this event can really not be overstated, because all of us in this room basically signal that the fight for reparations is a collective fight that concerns us all, not just the communities and people in the former colonies, but also here in the country of the former colonizers. And to me, this event also perfectly illustrates that there are opportunities which we now need to salvage. And if we all put our heads and resources together, we will be stronger for it. So it is key that after this event, that we continue these exchanges, that we continue to learn from each other, to draw lessons learned, to think creatively, and to pull in also all kinds of partners, the ones that are obvious and also the ones that we might not be thinking of, because it is a collective fight of so many. And also giving voice to the affected communities, because governments are intentionally not doing so. So we need to make sure that we do it exactly the opposite way. But also, I think it's important to celebrate the remarkable achievements that we were also able to listen to by Chief Taku and by Patrick Kauta and by so many others that we also listen to today, but that we also know of, because their perseverance is remarkable, and it's incredible how they're still tirelessly fighting on. And I think it's important that we give credit and that we also celebrate these achievements, because we wouldn't be here today now without their fight. So just to say that as well, and I think it's important for what I'm going to say about the work of Human Rights Watch as well. But I think we should be inspired by their fight. We should support them to really achieve that we see an acknowledgement of the colonial, and an acknowledgement and the reckoning of the colonial legacies of European colonizers, and also to make them recognize that these wrongs need to be adequately remedied. But that also governments understand, like the German government, that for reparations, they need to be tailored around what effective communities say they need for their healing, for their repairing of the harms that they have experienced. And for that, it is necessary that these communities also have a seat at the negotiation table. But this event also demonstrates that we have a lot of work ahead of us. But as Human Rights Watch, we have dedicated ourselves to the fight also of the right to reparations. And my colleagues in the US, you can see some of the work on our website, have done remarkable work also on reparations in the US context. But also recently, we published a report on the right to reparations of the Chagossian people. Chagos is an archipelago next to Mauritius in Africa. And they are still to this day prevented by the UK government to return to their island. And they have been asking also for reparations, and so far they have not received that and have also not been able to sit at the negotiation table. Once again, we're seeing secret, intransparent negotiations between the government of Mauritius and the UK government. So you can pick up a copy at the entrance. We have a few here. Obviously, you can see it also on our website, and I really encourage you also to watch the video that we created with the launch of this report in February this year, because it's really, truly powerful and gives voice to the Chagossian people and letting them tell what they need to see now from the UK government. And as a researcher on racism in Europe, one of my priorities going forward will be reparations, because there is just no way to tackle structural racism in Europe without tying it also to work on historic legacies. And Human Rights Watch recognizes, as I said, the tireless fight by so many for the right to reparations in Europe, different European colonial contexts. And we would like to connect the different movements by creating a transnational network or coalition that on reparations that will help deal and address collectively the harms done by European colonial legacies. And the coalition will allow us to think big. It will allow us to share resources. It will provide tools for the movement that will counter these government narratives. It will generate, obviously, more media attention. There is room for campaigns because we will all be always exchanging and working together. And we will also provide, obviously, opportunities for advocacy with governments or other counterparts. But most importantly, also, it will show solidarity with and also empower those that have been advocating for the right to reparations and the affected communities, obviously, most importantly. So we need to see reparations now, and so a coalition will really put all of our strengths together. And just lastly, Human Rights Watch, we are dedicated to the right to reparations, and we hope to obviously work with many of you in this room together and others that cannot be here today, but that is the commitment, and hopefully we'll bring many people, different, various actors together.
Thank you so much. It's hard to follow that one. Thank you, Almaz. But I do want to turn to each of the remaining panelists and speakers today with a charge for us as you leave. What do you hope we take away from our time together this evening? And how can they support you in your work? I'm going to let this be whoever wants to speak first. Sarah, I see movement. Yes.
What can you do to support our work? Obviously, share research. Work collectively. And yes, I'm being honest. Funding is essential, especially for these sort of litigations. It's a fact. But also, and I just can repeat that again. I'm so happy that Alma's starting this coalition, and because the more voices, the bigger we get, and the bigger and louder the claim for right to restitution will get. So, funding is really what I want to conclude on, really.
Yes. Anyone else have some demands, requests, or advice for us? Patrick?
I don't know. Litigation is expensive. It's a very expensive commodity, and we could start there. And the other one, the other resource that one needs is education. of the communities to find their worth and to imbue confidence and hope that one day things will change. So I think one needs those sort of resources. The sooner the better.
Thank you. Chief Taku or Karina? We leave it to you, Chief. Yes. Your closing words, please.
Yeah, very, very briefly. I'm a public figure. I invited, when I say you can put my email address out there, I would like to engage with anyone. You have a question. Already, I have more than 32 former interns in international organizations. And I really value their support. What I'm learning today, I think I'm back in school. And it is very, very humbling. And humility for me is an attribute of strength when you accept and learn from the experience of others. I think I've learned a lot. I'm taking the education out there. And I can also tell you that my entire community, every Bama on the face of the earth, is aware of this conference. And they're waiting to know exactly what happened. Anything that we talk about this, they're waiting for that. So this conference, I saw one of the notices was that the world is coming to Berlin. And I think indeed the world is here. The world is you and me. And I'm ready. At any time you call me, I will come. And actually thank you so much that this demonstration of people who can value time and come and sit here and who have done so much to change the world. And we heard Patrick again talk about contributing to changing the world. I think we're capable of doing that. I think we will do that. I think the voice of justice will prevail. And I think they may be in the majority and may have they may control the system, but we are closer to the true conscience of humanity. And I think we will prevail. So you can give my email address or any address to anyone anytime, please.
Thank you. Thank you. Thank you for the generosity that all of our speakers, in fact, have generously offered their contact information. If you received a handout and when you arrive, the contacts are there. We take quite seriously. We're not pretending that what brought us all here is to connect. This is not a space of gatekeeping or a space of elevating just one group's expertise. We're working together on this, and I'm just so proud and that we're really just honored that Open Society Foundations, our justice initiative, were included in this conversation, and we hope to continue to participate in them. I wanted to offer a few thank yous before I turn it over to our local co-host for closing. First, I really wanted to thank our speakers, and if you could join me in that as well. And I really want to thank the Academy of Arts and Sciences. I don't know how many of the staff are still around here as we are getting into the late hours, but they have been incredible in trying to design this space as one that would be supportive of us, and really quickly prepared the space after a major flood last night. We saw the video of it, and making certain that you all would be comfortable and placed here, as well as a little bit of flooding that happened right when you arrived as well. So thank you for your flexibility with that as well. I want to thank the members of the organizing committee. You've heard one name in particular who has she hasn't slept, y'all, doing this work for you. Her name's Nora Henter. She has to come here up front. Nora. Other members of the committee who've already introduced themselves, Sarah, Mani, Almaz, Tafera, thank you so much. And then as well as we have other colleagues of mine from Open Society, Nina Ippolito, Balin, and Rebecca provided amazing back support. None of this could happen without the team. So thank you so much for that. And then we want to thank our event coordinators who are sitting not at the sidelines, but running this in every space. Ingo, Kimberly, Kim, and Patrick of Journal Group. We have, this could obviously not have been done without you, but they have built a space and a conversation and been so thoughtful in ensuring that the way we operate is reflective of the values, that this is not just going to be something that's speaking to people, but actually connecting with our hearts. So thank you very much for your tremendous support. I also want to thank our many volunteers. I do not have all of the names, but I really want to thank Britta in particular, who traveled here all the way from the US to be able to support our work today. With that, I want to turn it over to Wolfgang Kalk, who's actually a leading German lawyer and human rights activist, many of you know. He spent more than 2 decades in the global struggle to hold very powerful people and governments accountable for their abuses. He's the founder of the European Center for Constitutional and Human Rights here in Berlin, an organization that's prepared key legal actions against politicians, military leaders, and corporations for crimes against humanity. I turn it over to you, Wolfgang, for our final words. Thank you so much, and panelists, thank you so much. We can step away. Thank you.
Yeah, thank you, Gretchen. Good evening, everybody. It's quite late, and that shows that there is a need for this discussion, but I want to keep it short. I want to start with Patrick's remark that lawyers, he said lawyers are conservative. And I would say that's rather an understatement. Lawyers are not only conservatives, but lawyers stood at the side of the colonizers. Lawyers are responsible for the mess of the colonialism, for the colonial crimes, because they try to legitimize it with legal theories. And some of the theories, as Karina was saying, are still alive today. So we have the evolution of reparation principles. The title had to be short. It's wonderful, but it could be longer. It's from the moral and political claim of, for example, Herrero and Nama, Chief Taku and others, to some legal ideas of random lawyers, and the random lawyers have to be named. That's the colleagues from the legal scholars from third world approaches to international law. They were completely outsiders. So 10 years ago, it wouldn't have been possible to even convene an event like this in Berlin. We have to be very clear about it. The Namibian case, the Cameroon case, they were not known at all in the public. So due to this effort of the communities and due to this, to the legal grounds, the Tway lawyers laid, we are here now as lawyers, and we have come quite far with, now being able to present contemporary remedies, litigation for reparation. But there is still a long and winding road ahead of us, because the next step would be serious law, serious procedures and serious decisions by courts. And I'm not really sure if we want anyhow achieve something significant. So my view is it's important that we have to create networks like this, where lawyers, as Sarah said, are trying to apply law from below. That's new, because lawyers, again, are not only in the colonial question, standing aside of the elites. Our lawyers here in Germany are legitimizing pushbacks and serious human rights violation at the EU external borders. Our lawyers here, your lawyers in the US, the lawyers in the UK are aside of the corporations committing human rights violation, violating social and economic rights everywhere in the world. Our lawyers, your lawyers, stood at the side of the torturers, not only in the Iraq war, but also in other wars, and they stay impune until today. So this is a heavy, heavy and hard struggle. So it's wonderful that we're here, it's wonderful that we have groups like this, but we need to mobilize much more people, because this is not only a legal struggle, this is a legal and political struggle. The best thing is that the lawyers of the other side are now unarmed, because it shows more and more that their arguments are not valid anymore, but that is not enough to come a little bit closer to some kind of justice. We need to mobilize the political and public, which is, from what I see, difficult in all of our countries. So this is a step ahead, wonderful, but there need to be a little bit more of attempts, not only of us, but others outside of this room. So congratulations to this event, and let's move on. Thank you.